we also understand that you closely participated in the case of Suprio versus Union of India, which was probably the most talked about on LGBTQ rights. And we also saw that there were 3 different judgments written in that. So what do you have to say about the position that holds today in terms of that judgment, and how do you see going ahead in the future, that what should be the position?
The judgment's well known as Suprio, and it came after the aftermath of Delhi High Court Justice Shah's judgment, and then came to Supreme Court, where first it overturned the Delhi High Court judgment, the Naz Foundation, and then the law was again changed. Now, the aftermath of that and K.S. Puttaswamy was that if you have a right of bodily autonomy, then you have a right to choose a partner, whether of a heterosexual couple or a homosexual couple. From that, it evolved to the fact that do you have a right to same-sex marriage equality. And to my mind, the US judgments, of course, on this are well known, but there were 2 South African judgments and 1 judgment from Austria. We argued on behalf of the petitioners that if you have a right of equality, that right of equality includes your right to same-sex marriage, and that includes the bundle of marriage rights, adoption, inheritance, insurance for each other, joint accounts, small things which we take for granted as heterosexual couples. Those small things mean a lot to people of the same sex. Why shouldn't they be able to have children and give them their names, for example, or call them both their children rather than one person's child? Why should a couple who goes from India, marries in the US, has a child, have the child recognized there, come back to India as an overseas citizen of India and not be recognized under the Foreign Marriage Act? I thought those were some issues. This right to family life, which the UN Charter says. Family life includes having a child, having a wife, having a spouse, all those. Can you read that into the Hindu Marriage Act? Can you read that into the Special Marriage Act? Unfortunately, the majority said no. To my mind, South Africa and Austria through statute, South Africa through court. And that's why I admired that judgment more, or that judgment was more apposite for India, was that if you can possibly recognize this fact that same-sex couple also have rights, and they said, let them have rights, but not to marry. Then the next judgment came that if you have all the rights as a same-sex couple, then why not marriage? But Indian courts took a slightly more, I thought, a more conservative view. I don't agree with it. It's a view. I hope we'll evolve and have another view after some time, that no, this marriage is only a statutory right. But I don't agree. The Hindu Marriage Act is statutory, but marriage was not a statutory right. It existed before the Hindu Marriage Act. So I don't agree with that view, and it's a wrong view to my mind. And even so, even if it was there, what the US did was it made little pinpricks in each law, bringing right to same-sex couples, till it has evolved in some various judgments breaking down one law or the other. So you could take it that spouse means spouse of the same sex or of a different sex.
Yeah.
And it could go for even transgenders.
Yeah.
But I guess our society has to be ready and our courts have to be ready.
No, actually, and if somebody who saw this as an outsider, we thought the reason why they may have prevailed, even though the judges who were deciding the matter were quite keen on deciding in favor of it, is because of the scarecrow tactic that, what if you allow this, it will open a Pandora box, maybe the society will stop getting married. But I don't think that could be the point of view, because it's not that LGBTQ did not exist since the ancient times. It's always been the case.
No, I think Justice Bhatt had the slightly more conservative because of statutory. So they've referred it to a committee. But I feel we could have, I feel we should have allowed that. See, the moment that you have, I think it was Navteej Johar or whatever, have allowed them to have consensual relation, then this was one step earlier, later. Most people are not ready, but this is only for those who are ready. It will give them protection. Otherwise, same-sex people run away, then they file a writ, then through habeas corpus they get protection if they are living together. Why not?
Just give
why not just give it? Marriage is not necessarily an institution. It wasn't, not necessarily a statutory institution. It was an institution. So every country in the world, Singapore, other countries, everybody was looking to India for this very progressive judgment, I thought. But the conservative view is refer it to a committee. So...
Yeah, and that's an excellent point, because marriage is not statutory in terms of Saptapati. Saptapati was what? It's marriage through in front of fire and iron. So if that could be proven, then why should you limit it to the body of an act? And I think you're right. I think these issues will, with passage of time, because we are a country who respects liberty, hopefully this too would be looked differently. Actually, now moving on from a slightly underused act, I would now talk about the most overused act in something which you have been part of. Invariably, many judgments which have traveled to Supreme Court and in High Court and all the other various courts, the family law. And it's a hotly debated topic, because we see a host of issues which is plaguing the system with an overly zealous act as well, because we all understand that women can trigger laws even when there is no case at hand, and can make issues which are far wider or far bigger than which they actually exist. Sometimes it has culminated into suicides also, like in the case of that Subhash, who was spoken a lot about. But I want to break it down, and I want to start by topic, because it has a wide range of issues which needs, I think, and point of view like yours would surely throw a lot of light upon it. And firstly, I want to touch upon Alimony. In the Alimony, the fact that we don't have a very, very standardized formula, and not just a single act which sets the tone for the maintenance which one can be awarded. How do you see this? Like, where does the answer lie in ensuring that the Alimony law could be? How could it be better in the future? What should be the way forward to ensure that it is more streamlined, be it for men or women, either way? I'm not really specifically looking for answers for just one gender.
A very difficult question. Reason is that we are not gender neutral, we are gender sensitive.
Right.
So you have the Hindu Adoption Maintenance Act, in which you can file under section 18 and 23. you have Section 125 CRPC, which is a non-religious because it's in the penal laws.
Right.
In the amended BNSS. You have Section 24 of the Hindu Marriage Act.
Right.
You have permanent alimony in Section 25 of the Hindu Marriage Act. You have the Domestic Violence Act, where again you claim maintenance and right of residence or right of residence in a shared household. So we have 4 or 5 enactments.
Right.
Now we have trigger-happy lawyers and clients who will want to file in each of them the same relief.
Right.
And unfortunately or fortunately, our courts have said, please file as many as you can. There's no restriction.
Right.
So we are already overburdened court system.
Yeah.
If we had a system, if it took only 6 months or 1 year, or I think the DV Act says 2 months, but it takes actually 7 years, I don't know how long,
Yeah.
then you would actually reduce the court dockets.
Yeah.
That's the first, most important. So I feel somewhere the courts have to say, all maintenance laws include with it a right of either rent or residence or whatever, so people won't go into the DV Act and into the HAMA and into this.
Yeah.
This is one. Second, we thankfully have some non-religious secular enactments like the 125.
Right.
So every religion can go under that, which is what you need. Now, how do you standardize? There's Justice Indhu Malhotra's judgment and Rajneesh Neha.
Correct.
She's tried to but you will have a person who's driving a Mercedes, who's having a Patek Philippe watch or a even more expensive watch. I don't even know their names. And who will then say, I'm earning 2,500? And what do the courts do with this? And at the same time,
Right.
I've seen a case of a person whose husband was actually a rediwala, but she said he earns 10 lakhs a month. Now the judge has only the file to look at.
Right.
Our tax laws are not so stringent that everybody is paying tax.
Yeah.
So you don't even know which is the truth, which is the falsehood.
Yeah.
You have a person owning, say, a tower. I can't name them, but they own these huge malls.
Yeah.
And he comes and says, I don't earn anything, and the wife is given a pittance. Our laws are absolutely without guidelines because people don't pay their taxes.
Right.
And because people don't pay their taxes. So I'll tell you something which is very interesting and which has started evolving in Supreme Court, which is duration of marriage.
Yeah.
Now in India, duration of marriage didn't marry because when you have arranged marriage, you played a fraud on a girl. Whether she is left in 1 day or 1 year or 5 days makes no difference.
Yeah.
She should still get the same maintenance and alimony.
Yeah.
But there will be people who have girls who have defrauded and left within 6 months, 1 year.
Yeah.
Now, should they get half your estate of half your income?
Right.
So, this alimony in India is very skewed for these reasons.
Right.
Now, Rajneesh Neha has tried to bring some semblance in it, but people put all the properties in their sister's name, in their brother's name, in their father's name, show that they are earning 2,500.
Yeah.
So somewhere the court's first most important is maintenance has to be decided within 3 months or 2 months.
Yeah.
You cannot give 3 years.
Yeah.
I remember some girl from Defense Colony came to me 20 years ago and I turned her away because I told her that your maintenance will take 1 year to decide. She had an autistic child. She was very well qualified, but she said, because of the autistic child, I can't work and I don't have parents. I said, it'll take 1 year. She says, I do not have the means to survive. I will keep taking the assault, I'll keep taking the battery, but I cannot leave the roof over my head. I can survive 1 month, 2 months, 3 months.
Yeah.
I cannot survive 1 year. We turn back such people because they can't survive the system. Now that's unfortunate.
Yeah.
If that's what I hope I'm answering the question
absolutely.
as
You
you
know,
would. I mean, the
I-
answers are perhaps a little skewed, but
No. I'm glad that I'm getting this answer because, in fact, what you have answered and what you spoke about the Supreme Court actually is codified in some countries. The fact that if you have had a small temporary like a marriage which has not lasted more than a couple of years, vis-a-vis comparison to someone who has been married for, let's say, 20 years, makes all the difference in countries like US, UK, for the reason that the person, for an example, is well qualified but is not working because they are married. The one who's been married for 2 years or so will only get an opportunity to come back to a situation to redeem themselves. So it's like a temporary maintenance till the time you get back on your feet. So it's like a short temporary arrangement. Whereas a person who, like you rightly said, that somebody who sacrificed their entire life for the betterment of their family, for the betterment of the household, and has chosen not to work or was not able to work, that person, of course, should be given far more amount. The other fact, which you pointed out, and I think is also begs consideration, is that the amount of untruthful things that we get to see in court, and of course, Supreme Court to some extent is trying to come down heavily on AORs and people like that who are deliberately making false statements. But I think, like we see this in other countries, there is probably a need for harsher punishments so that people stop lying. And I hear this a lot from people from your generation that back in the day, this was not the norm. Back in the day, it was not the norm that people will just take court proceedings for a ride. But that's seriously changing, and because of which I think there's maybe a requirement for change of law.
see, I think you have to take action whenever there's perjury. You have to. You can't just let it pass. There will be some small slip-ups, like somebody is doing one ad hoc 20,000, internship kind of thing. Maybe that slip-up, they're trying to be over-clever that, look, I'm only doing this internship for 20, why don't I cover it? But there'll be people who are working. There are people who have jobs. There are people who are in government jobs who lie and they just get away with it because some of the courts have said there will be some amount of lying in maintenance cases.
Yeah.
You can't be just lying
Correct.
all the time. So there is, and this, you see, now in the West, maintenance is given irrespective of fault. So you are guilty of adultery, you are guilty of cruelty, you are guilty of anything.
Yeah.
They do not even look at it.
Yeah.
And I don't know, maybe our moral structure says somebody is in adultery, they're actually two-timing you.
Yeah.
Why should they get maintenance?
Yeah.
Or the same amount of maintenance where someone who's been loyal.
Right.
So I believe that our laws have to evolve and change.
Yeah.
I don't agree with the system which says somebody is totally guilty of adultery all the time and yet you give them the same amount.
Right.
But I also see some sense in saying you have to give maintenance, just get on with it, do it soon, finish the alimony, close the chapter, and move on in life.
Yeah.
But we don't do that.
Yeah.
And therefore, we are doing something. 2 years later, we give one huge lump sum, and then execution is a problem. So in India, alimony maintenance needs to evolve and become much, much quicker.
Yeah.
Whichever way they go.
Right. In fact, I was another thing which now is hotly debated, and in fact maybe could be a solution that even the current Chief Justice wanted and ensured a drive for mediation in the country. Why not? And we only have this pre-mediation clause under the Indian Commercial Courts Act. Why not have a mandatory provision? Because at least I see in the Supreme Court level or the High Court level, sometimes when these disputes come there, they do get settled, right? With the best of mediators, or maybe in front of the court they set them in line and ensure the things do get settled. But when the trial is happening at the lowest court, it's just invariably going on for years and years together. Like I know somebody who have not been, I'm doing a case where somebody who's not been living together as a couple, the children are grown-ups. The children has said that he doesn't want to live with the mother because they've had a tormenting relationship, have been living apart for almost 20 years. But the matter is just being a drag on because it's stuck so why not have a mandatory mediation clause maybe in these acts?
I was just speaking to someone, and the point which was being made was, you have section 12A in Commercial Courts Act.
Yeah.
But most mediations are non-starters.
Right.
So the way the courts are saying, go for conciliation, go for mediation, but there is another viewpoint that unless litigation fatigue sets in,
right,
mediation's not going to happen. If they had to settle out of court, they would have settled before they came to court.
Right.
So and let me tell you, every trial court, because the burden on a trial court is huge.
Right.
Whether there is mandatory mediation or not, they will send each party to mediation at least 4 times during trial.
Right.
And it should not be that you get an unfair deal because you can't afford a lawyer. So that's the only problem.
Right.
I feel conciliation, mediation as mandatory tryouts are not bad.
Yeah.
But then
does not get the kind of result.
Mediator has to be one honest person with integrity.
Right.
Because otherwise they will push the weaker party.
Right.
In order to achieve their goal that, look, I had a successful mediation. This is the only fear I have of mediation, that our mediators are trained to succeed and not to get a balance. So that's my only reservation.
Right.
Otherwise, really, in a country where you are going to take 2 years to get maintenance, why not make the effort and save everyone?
Right.
But also, I'll tell you, there will be husbands and wives who, because of custody of children or because of whatever reason, will be or because they don't want the marriage to break.
Right.
Because there is still some part of society which feels that, for me, I've done no wrong in this marriage. My marriage is sacred, it's a Hindu marriage. There are girls like that. Or maybe even men, I don't know. But there are people like that who are very opposed to breaking marriage, and therefore we don't have arbitration in divorce. Whereas we are having it in the West.
Maybe
we are not having it in India. And I feel a family arbitrator or a mediator may actually be a solution.
Right. Well, in fact, slightly on a nuanced way of looking at this settling of marriage disputes, maybe it's time, and Goa being the only exception to this issue, that where prenup are permitted. And so our line of argument is that it gives a sense of financial literacy and certainty as to what do you expect of a particular marriage, and maybe it was not contractual from religious standpoint and whatnot back in the day, but for the benefit of greater good, maybe it is time to permit prenups in India.
The only prenup clients I've had are people, almost the only ones, are people going in for second marriages, because it said for once bitten, twice shy. So a lot of people come for prenups, but they come second round.
Right.
Now, first round, there are people who will come, and it makes sense for people to do prenups, but only if they have a equal bargaining power.
Right.
Here in a country where in Bihar you have tilak, in Jharkhand you have tilak,
Right.
you are already negotiating your price, what will you give at the time of marriage. There may be inequality between men and women for being able to negotiate prenups. So prenups, and it's a very strange anomaly that you recognize post-nup. So you recognize an MOU entered between husband and wife
Right.
if they are breaking up their marriage. But if before the start of marriage they are doing, instead of a post-nup, a prenup, India doesn't recognize it.
Okay.
So we have an anomaly,
Right.
to my mind.
Right.
If we recognize post-nup that they are in an equal bargaining position if they've got married,
Yeah.
then prenup also there may be a bargaining position.
Right.
And it's something where our law needs to get standardized
Right.
and acknowledge.
Right.
Why would you think a girl becomes equally empowered at the time of breakup if she was not empowered just a few days before that when she got married?
Right.
But as it is, we are slow to think or recognize prenups. I think somewhere we should go the way where countries like the UK, etc., they see, is it conscionable? Is this prenup conscionable?
Yeah.
Is it unconscionable?
Yeah.
Is it graded that if it's within 1 year of marriage, it'll be X? If it's after 5 years, it's X plus 5. If it's 10 years, it's 2X or 3X. So, somewhere, some of our courts will have to see justiciability and equality in the prenup, or that it is not unconscionable, then they can start bringing in prenups, perhaps.
Going forward, ma'am, the other aspect about false cases and misuse of false cases, which is a hotly debated topic, and I try to touch upon it, about the 34-year-old engineer also who left behind a video of his estranged wife saying that how she threatened him that she will ensure that he faces multiple false cases. And 498 after, I think, 138 NI jurisdiction being the jurisdiction of maximum number of cases, where we see everyone is more than trigger happy, and I could say guilty as charged that, whenever a person is doing a case against the husband, they're more than happy to rope in all the family members. They're coercing settlements and and so on and so forth. So where do you think is the solution to ensuring that 498 maybe is, or the usage of 498 becomes a little more streamlined, or do you think there's some other solution to ensure that this position changes?
So, what comes to my mind is two orders. I'll just address both. But which country in the world has a mental something an act under the penal code? No country.
Right.
I mean, there has to be preparation, then there has to be attempt,
Right.
then there has to be actus reus. We have nothing in 498. Which country in the world can say mental act is something punishable with 3 years? And that is why, and that it has affected my health. It has affected my mental well-being. That's enough. So, while I say that there are cases of extreme cruelty, there are cases of extreme mental cruelty, but honestly speaking, with the way the ethos is in India, it should not be a ground for arrest. And I think Arnesh Kumar has done yeoman service by saying that under 7 years, you have to give a Section 41A notice.
Right.
You can't just be arresting. Because otherwise, left, right, center. I remember appearing once in the Supreme Court when everyone thought this cruelty against women, no bail should be granted, even though he said, those ladies who carry that, those keys in here, they are the ones that make the mayor go. That's why no bail. And this was for a mother-in-law in a 498A. And it's honestly traumatizing. And it's not right. So we have to rethink about 498A.
Yeah.
While I say that there will be cases of physical cruelty can come under 325, 326, injury, all those.
Yeah.
But we have to rethink about this 498A, to my mind.
Right.
It is, in many cases, harsh cases make strong facts.
Right.
But there are others also.
Right.
And then there are made-up cases. So I can't. So that's about 498A to my mind. Dowry deaths, all those come in a different ilk.
Right.
Dowry deaths, girls committing suicide because of cruelty. But the case you just said about this man.
Yeah, Atul Subhash.
So I think there will be many Subhashis who go unnoticed.
Right.
When I do cases for men, I see there are many Subhashis in the world. And many Subhashis in India who are brushed under the carpet. It shouldn't take a man to make a video to kill himself, and then for eyes to open for 5 days and close again. Right. It shouldn't take a Subhash to have to do it.
Yeah.
Let's hope we learn a lesson from this Subhash. That's all I can say.
No, in fact, I'm not that I am some men's rights advocate, but I have seen this committee's report of Justice Verma, which actually did it after Nirbhaya's case in 2013, that there is a requirement of having gender-neutral laws under the IPC as well. But this is a 2013 report. We are in 2025 debating about Atul Subhash, and still there is no place for it. So, where do you think that could be a possible answer to ensure some kind of level playing field, or you think that because the numbers outweigh so much in terms of the crime against women that there should not be any men-centric laws at all?
So,
or gender-neutral laws?
we are such an unequal society. Is it time to make it gender neutral? I think perhaps not. But I think it's time that we, as judges, are trained. Because lawyers being trained will not help.
Right.
As judges, we are trained to discern the actual domestic violence from the non-domestic,
right.
Made up
Right.
case.
No, I mean, the other is that, like, POSCO is a gender neutral law. There doesn't seem to be a big misuse of it. But I suppose, like you mentioned, because the numbers are so skewed, maybe we are not ready yet. Actually, I want to come down to another law which probably has required a lot of debate for a very long period of time, which is the irretrievable breakdown of a marriage. That, how Supreme Court is the only court under 142 jurisdiction is exercising this. And despite n number of nudging, does not seem to be getting implemented as a ground under the Hindu Marriage Act. What do you think is probably the reason why it's not being done, and how do you see it panning out in the near future?
So I think it was 20 years ago that I was asked by the Ministry for Women and Child with regard to irretrievable breakdown, and there were a few other people, Mrs. Shamla Papu, me, the 2-3 other women senior lawyers who were asked. And I, for one, feel that the only reason we are able to say that marriages made in India should be dissolved in India is because irretrievable breakdown is not there, and because it is a fault divorce, taking marriage to be sacred. Now that has many repercussions for protection of NRI women.
Right.
I believe that if at all you have to treat marriage as sacred, which we have two Indias. We have the metropolis India and we have the rural India. And we have the rural India, middle class, morality India, where marriage for them is sacred. And now with people becoming wealthier, the mobility in the classes is so high. IT experts, other experts, engineers, lawyers, doctors, whatever. Mobility has become so much that sometimes a man gets an arranged marriage, has moved on into a metropolis, ideas don't match, did the arranged marriage and then wants to walk out of the marriage. Those are the cases which will be very harsh on irretrievable breakdown of marriage. So there was a big debate on this, and ultimately this was the debate. That what do you do when there are two kinds of India? You have the urban elite India, where divorce may not be much of a taboo, and you have the
rural India.
The rural or the urban non-elite middle class person who's a housewife looking after children, who feels her life will be shattered. So you come across powerful, empowered women who are the first to say that there should be irretrievable breakdown. So one suggestion came that irretrievable breakdown should be there for women and not for men. So this was the big suggestion at the end of the day. And I thought that was so unequal. How can you say it should be there for women because men may misuse it and women won't? So this can't be, the law can't be so unequal. So whether we do it one way or the other, we have to realize NRI women will not have the protection when they marry from India. And the second is that whole class of one part of India which actually still gets traumatized by divorce.
Right. So maybe like having under the criteria, if it was to be a criteria included, there should be enough trial rather than just time space being a ground.
Yes.
Like how the Supreme Court is saying that 3 years or 5 years should
6 years, it's saying.
Should not
but this is a tough one. They also say trial should go on, 6 years should have gone. I don't know. I still come across very many women who say we'll jump off the cliff rather than get a divorce.
That's true.
And then you get other women who say, for God's sake, we are empowered, if we are equal, then we have to call it a day and move on in life.
Now, moving on to the next part of family law, which is also highly debatable, and that is to do with the shortcomings which we see under the custody law. And so, I mean, one hotly debated topic is also that how the HMGA Act also has this natural guardian to be the father, and only after him. And so, what is your position on that, and how do you see that as a maybe is that something that should change for time?
So we had challenged this on for a case called Neela Deshmukh or some such thing 25 years ago. Manushi had helped us.
Oh, wow.
And this lady had wanted to challenge that the Guardian Act is very skewed. We challenged it, and then Supreme Court, including in many other cases where we wanted tribal women having equal rights, etc., said, go to the legislature, forget us, and we are not interfering.
Yeah.
So luckily, many years later, I think it was in 2000 that Geeta Hariharan came.
Right.
So I think that Leena Deshmukh must have been in the 80s or 90s because this came in 2000.
Right.
Geeta Hariharan.
Yeah.
And Geeta Hariharan basically says that if the woman's looking after the child, if the woman's really the caretaker, if the man is an abandonment, etc., the mother is equally the guardian,
Right.
though not on paper, but she's equally. And this is how Supreme Court had sort of brushed me aside when I had filed that case of Deshmukh, saying, in law, we don't discriminate against you, in fact. So why do you worry? But of course we worry.
Yeah.
Why shouldn't a woman be an equally a guardian? Why should it be skewed?
Yeah.
So to my mind, that's a very unequal enactment.
Right.
And it should not be on the paper book,
Right.
even though Geeta Hariharan has come into being.
Right.
And there are two aspects of it. One is guardianship, the other is custody.
Right.
And ultimately, the question is, who is the primary caretaker? And our law has said primary caretaker is the husband because he's the only one who has money. And this was the 50s and 60s. Then 70s, 80s, or maybe more 80s, 90s, it changed. No, woman is the primary caretaker. In any case, Section 6 says that a child under 5 should be normally in the custody of the mother unless child is illegitimate, then obviously in the custody of the mother. All that. But the law has evolved now and is trying to say, let's give some rights to father.
Right.
So, men's movements, many men's movements saying, I can't be only a Santa Claus father.
Yeah.
I can't come only on Christmas, give my child a gift, see my child for 2 hours and go away.
Yeah.
So, this has to change. Actually, it has to change.
Right.
And it will depend on how caring or how sacrificing the father or mother is, but whether it's the father or mother, they should be equally entitled to custody. And it's also who's doing the sacrifice.
Right.
I have seen father give up the chance of a competitive job to look after their child.
Right.
I have seen fathers who've done second role only to look after the child.
Right.
Now, if you have fathers who are doing that, you can't tell the father that you only have to bring a birthday gift and a Christmas gift.
Right.
So,
This
honestly, despite what the Law Commission has recommended, despite what the Bombay guidelines said, which 4 or 5 states, including Madhya Pradesh, Maharashtra evolved, which gave more rights to men, most of our courts do not recognize the rights of the other parent.
Right.
And this, to my mind, should change,
Right.
has to change, if the father is not just a man who will say, if I see my child for 1 hour, it's enough. Because there will be fathers.
Right.
So you look at the past history and then see the present.
Right.
And a mother should not be able to make cases of 498A against the father so that he can't come back to India. Other cases, POXO cases, so that if they are genuine, very good. But if they are false, so then, to my mind, law. So one of the lead judgments is a beautiful case called Vivek versus Rumani. In fact, I was one of the lawyers in that, Justice Sikri. And he talks about parental alienation, something which Indian courts don't address.
Right.
They think they will ask the wishes of a 3-year-old and go by the 3-year-old's wishes. I mean, what does a 3-year-old know?
Yeah. In fact, one of the solutions that you touched upon, in fact, and which could be a way forward for the child custody, is joint custody, right? And it's not something which is the norm, but like these facts and circumstances from case to case basis, where fathers are also not only just interested in being Santa and want to do more, that you see as a answer happening more often, or you think that's also one thing of the future?
It is probably of the future. We've had cases where the fathers have fought. We've got orders from the court, but in implementing, the mother has poisoned the child so much, or if the father had custody, he has poisoned the child so much. And then you see these children crying inconsolably. So the question is, you have to sit down with a counselor, you have to sit down with a mediator, you have to sit down with a psychiatrist, you have to sit down with both lawyers. You have to thrash it out.
Right.
Honestly, I feel that's the best way. Mother's feeling nervous, she may not lose custody. The father's fighting because he feels that way. He may have to pay less maintenance because he'll keep the mother distracted in child custody. There are all sorts of reasons why these battles happen, apart from the real, genuine reasons. But those poor people who really, genuinely want to have a big share in the lives of their children, they are the ones who need some attention. And the children need the attention. So, I don't know about joint custody. I feel maybe it'll tear up the child. But even if you have, say, 5 days and 2 days, or 10 days and 3 days, you are giving each parent a decent time. How much time do I spend with my child when they are small really meaningful, good, quality time. Probably 3 hours in a day.
Correct.
Probably half an hour in a day.
Correct.
If I do it over 2.5 days, even as a father or mother, and I give concentrated, good, quality time,
Correct.
I think I'm making up for the rest of the 5 days.
Absolutely.
So I feel, this system of sometimes the West of 1 week may be slightly dislocating for a child.
Right.
So leave the child with the one parent.
Right.
And the other parent can have good weekend, 2.5 days. And holidays.
Yeah.
Holidays are there.
Yeah.
So all in all, we have to become progressive and realize that the other parent also should have a right, and most importantly, the child should know both parents.
Right.
It should not be that the child, for some reason, the child loses one parent and doesn't have anything to do with the other parent.
Right.
That will then traumatize that same child you are protecting far more.
Okay, thank you so much on those aspects. In fact, now I want to shift away to a topic which is closely associated to expectations, but not of that of a child. And this could be more personal than anything more to do with the viewers. But as a second generation lawyer, right, somebody who is born to a very big lawyer herself, and also has family members in a brother who is also doing such good work. How have you personally dealt with the expectations of a second generation, and what do you think would be, or how do you say, or what do you do to be more comfortable in your own skin?
So, first,
yeah,
there are not that many expectations of a woman. So, when I was a second generation lawyer,
right,
my father spent most of his time dissuading me from law. Said, you're a gold medalist, you're a topper, you've been to Cambridge, do the IAS, crack the exam, do all that, and I wanted to be a lawyer.
Right.
So I didn't have that peer pressure or the pressure of being a second generation.
right,
Except to the extent, obviously, as a woman, you have to crack it. It becomes slightly difficult, more difficult.
right,
But there was no pressure as a child to do well, your parents doing well. I'm sure Shivani may have that pressure.
Right.
Because now women have come into their own in the profession.
Yeah.
When I entered the profession, there were no women, so there was no
pressure,
there was no pressure of that nature,
Right.
that the girl was expected to excel
Right.
in the law. Siddharth's doing well, and he's a brother, but he's like a son. He's younger than me. So for me, it's a protective instinct.
Okay.
So it's a wonderful feeling that he's doing so well. The pressure will be, for example, on you, will be on Shivani.
Right.
And I keep saying, please don't work under pressure. Enjoy yourselves.
That's true.
I want that. But obviously, this is internal to the person.
right,
There are children of lawyer parents
right,
who know that they want only a good time.
yeah,
There are children who have the peer pressure.
Yeah.
I think it's how you yourself view it.
right,
My own sense of the battle or satisfaction is
yeah,
do whatever you do well, whether good or bad or small or big comes your way.
Yeah.
Just do it well and don't be in the rat race, because ultimately life is too small.
that's true.
Life is too short.
Right.
Before we realize it, you can see that, have you done all the things you wanted to do? Have you enjoyed? Have you traveled? Have you studied? Have you played? And obviously in the profession there will be regrets. I was much of a sports person. One of the fallouts is that the sports has gone out of my life. But there are many people who've kept it up.
Correct.
So my occasional one game or something is not really sports. And a lot of people, for them, for example, health is a big issue. The younger generation have the sense that they will exercise, they will eat well. We probably didn't eat as well or as sensibly or on the right times. So I think all of that is what should make the second generation, not what we did stupidly or well, but they carve out something beautiful for themselves.
Right. Moving away from Nepo kids, I mean, of course, Nepo kids have their own privileges and their own drawbacks, but let's actually shift away to the young lawyers in general, young female, young lawyers in general, especially those who want to have such an aspiring career where they excel, probably become one of the leading names in one industry and still has the bandwidth to do a very wide variety of work as well. What would your advice be to such aspiring lawyers who want to be in litigation?
I would want all young people, I mean, corporate law is wonderful, in-house is wonderful, and they are in-house, if you're good at your work, has its own advantages. You don't need to procure clients, you don't need to network, you just need to be good at your job, and you keep rising along the ladder. Corporate law has its advantages because in corporate law, except for few at the top cracking deals, mergers and such transactions, the fact that you are doing a solicitor's job as compared to a arguing counsel litigation job, that also has its own comfort zone, because the firm will get a lot of the law, or by reputation, being in a good firm, after some time you will get the law, and others will execute it. So to my mind, in that sense, even though it requires as much capability, as much competency, litigation is perhaps the tougher line. And for those who are younger, I can only say, for me, the most important quality in a human being is humility. So humility, hard work, dedication, and I think integrity. The profession has always been mooted as being sometimes less than, say, the medical profession. Everybody says medical, noble. But I think law is a very noble profession. You are doing a lot of service to a lot of people. You do some pro bono work, some other work where you are helping people in distress. Even after taking payment, there are clients, if you can do their work with integrity, what more would they want? Whether you are charging for it or not charging for it. So I feel that for young lawyers, and I speak equally for men, but I speak more for women, because I see that they have more struggles. I mean, COVID time, I would sometimes speak to some of the women, younger colleagues, and they said, look, out of two of us, one, we have a parent who may have comorbidities, we may have children, then one of us has to sacrifice. Domestic help is not there. Who is it going to be? So most of the women said, well, it's we who have to take a back foot. For all those people, I want to say that success does not have parameters of number of years, but yes, listening, sitting inside the court rather than always standing outside and talking. These are some of the things. And always respect for your seniors, respect for your colleagues. We do get angry sometimes. We do lose our tempers. But we must remember, we are colleagues. We are there to serve people, but also to have respect for each other as members of the bar.
Right.
So that's all I would tell them.
Thank you. That's really, really meaningful and insightful. Actually, another consequential question, because at least I see this in my own office, and it's a challenge, and I see that as the newest generation which is coming out, which I don't even what they're called, alpha, beta, God knows what they're called, Gen Z. So they are aspiring. So there is one line of thought, or one school of thought says that there has to be some work-life balance, and you need to enjoy your own life as much as you want to enjoy the work life. And then of course, then you have people like Narayan. I think S. Murthy, who said that you should have 70-hour a week work week for people to really excel at their job. So where do you see things moving forward? How do you say that people can excel? Where will your balance lie?
So it's this is funny, but I just read it yesterday or day before. So this was a Cambridge study on how one excels.
Right.
And it said to excel, you should do, say, 52 minutes of concentrated work and then take a 17-minute break. Oh. So I've decided that every time I'm arguing, after 52 minutes, I'm going to tell the judges, I'm taking a recess. Would you like one too? So, how do you do this? So Gen Z, to my mind, have to realize that you are not going to have that Mercedes-Benz on day one. You are not going to have all the top shot quality which people after years of hard work have had.
Right.
Gen Z has to realize this, that behind all the success of all these people is extreme quality of hard work and sacrifice.
Yeah.
We can't just say necessarily today's a dinner party that I have to go to. And I recall this very interesting thing that I think I got mehndi and I was supposed to get married, and then suddenly I had to go for this urgent matter. And with all the mehndi, I landed up in court. And the district judge asked me, aren't you supposed to get married tomorrow? I said, yes. He says, then what are you doing in court? I said, arguing for a stay. When I get it, I'll go to get married. So sometimes there is sacrifice.
If you were to take back and this, one prime point of lesson which you hold very closely to yourself even till date, which you would want to share with all of us, which helps you go stronger?
This is a difficult one.
Yeah.
I have to think.
Right.
What lesson would I go back with? I have loved my work all the way. So I have this big advantage. When people say there's a work-life balance, and I say, it's all work, I don't know what is it, what more there is to life. But the fact is that there should be work-life balance.
Right.
And each of us need to take off a little time.
Right.
A lot of people ask me this in the profession.
Right.
That, you have so many holidays. You judges have so many holidays.
Right.
You lawyers have so many holidays. But look at the number of hours we are putting in. And look at the reading before we go to court.
Yeah.
What do I learn from this is, I guess, not to take myself too seriously, because all of us take on blood pressure because we are taking other people's tensions.
Right.
We take on other comorbidities because we think we have to take on everybody's headache. But for God's sake, don't take yourself so seriously.
Correct.
Life is not about being too serious.
Absolutely.
So I think whenever you can have a laugh, whenever you can have a light moment,
Right.
I think one should enjoy that.
That's lovely. No, I actually was, in fact, trying to go for maybe a lesson which your dad shared with you, and which you hold on to, or some guru who you worked with.
My dad told me as a young lawyer, you should not be taking so many summer vacations, because that's the time when young lawyers get a break. This is the one lesson I did not learn from him, because I took all my summer vacations. I thought that if I work so hard through the year, then I need my vacations.
That I agree.
But I'm sure my dad... So, my dad was an extremely, extremely well-respected and he had a personality that if you walked into the room, they would literally be pinned up silence. His persona was that great.
Wow.
So I probably didn't learn that from my father, but I learned so many qualities. For example, cross-examination.
Right.
I think listening to him, my father represented every political party. He represented Mrs. Gandhi, he represented Mr. Jagmohan, he represented George Fernandez. So he did, and I saw from him the sense that you should be fighting for the cause irrespective of the politics.
Right.
And fight for liberty of the individual. I think I learned that from my father.
That's lovely.
I learned without going for many of his cross-examinations. I think I imbibed the art of cross-examination, and I'm good at cross-examination.
Great.
I imbibed that art perhaps because I think he cross-examined the best. And he had a very disarming way. I don't think I have that. But he had a very disarming way, very well, beautifully researched. Mostly I would see that in Official Secret Act, Coffee Posa, all those cases. I would see his cross-examination. And it would lay, because his research was so wonderful and his mind was so sharp. So I think I learned, I'm losing it because now I don't cross-examine so much.
Right,
I mean, going to trial
Supreme Court
court is lesser, all that becomes lesser. So you don't remain as good or as sharp. But those are some things which I feel I learned from my father.
Times to come. But thank you so much. I think, like I was mentioning in the very beginning of this discussion, that despite being in 13 years of the profession, I'm still scratching the surface. And this has allowed me to get a much more wider perspective onto many such topics, which despite all the research, I was not able to get. So thank you so much. And I'm hopeful that everybody else will also learn as much from this inputs that you've given on wide range of topics. Thank you so much for taking your time out and doing this podcast with us.
Thank you. After so many years, we are also still scratching the surface. So let's hope we can scratch enough. Thank you so much.
Thank you.